Welcome to the VS Criminal Defense Attorneys podcast, providing an informative resource on criminal law with a specific focus on sex crimes. From protecting yourself from false accusations to understanding the exact boundaries of the law, being informed is always the best first line of defense. This podcast series is reviewed and approved by attorney Michelle Villanueva-Scura.
In this episode, we want to explain the key differences between insanity and diminished capacity, and how they're used in Arizona sex crime cases. Being charged with sex crimes in Arizona is a serious offense with life-changing repercussions. But what if mental illness has something to do with the conduct or comprehension of the defendant? In such instances, legal principles such as insanity and diminished capacity can greatly influence the manner in which a case will progress. Arizona law allows an insanity defense on very limited terms, but does not recognize diminished capacity as an autonomous defense. However, mental illness can find influence at sentencing or lead to alternative results depending on how it's presented in court by an Arizona sex crimes lawyer. Realizing the difference between these two defenses and how they're used is essential for anyone who's moving through the criminal justice system on these types of serious and sensitive charges. First, let's review what counts as insanity in Arizona sex crime defense cases. Under Arizona statute, ARS section 13502A, the technical insanity defense is referred to as guilty except insane, GEI. It is a defense of confession and avoidance wherein the defendant must admit the act, but state that due to a mental disease or defect, at the time of the commission of the criminal act, they lacked the understanding that the act was wrong. Due to the nature of this defense, it is a difficult one. Succeeding in it means establishing that the defendant had no comprehension of the nature of what they were doing, or the distinction between right and wrong at the time of the crime. While there are a few cases that will meet this high test, it is not impossible. Succeeding on this high test requires a demanding approach and strategy. Key elements include the following. Strict statutory test. The defendant would necessarily have had to possess a mental disease or defect so extreme that he or she did not know the wrongfulness or lawfulness of his or her act. Arizona will not apply the volitional prong, lacking ability to control behavior, from broader models like the ALI and MPC. Exclusions. The law excludes voluntary intoxication, character defect, impulse control disorder, or psychosexual disorder from being regarded as a mental disease or defect to qualify for this defense. Burden of proof. It is the duty of the defendant to prove insanity. This must be done by introducing evidence that is considerably and highly more likely than not. You might be wondering why diminished capacity is not a defense in Arizona sex crime cases. Diminished capacity is a legal doctrine that defines the defendant's lower mental capacity to intend to commit the crime without being legally insane. It is typically raised in making the individual unable to have the necessary mental state for a particular charge due to a mental illness, trauma, or intellectual impairment. Unlike the defense of insanity, which can result in a finding of not guilty by reason of insanity, diminished capacity never excuses criminal conduct. Instead, it can be employed as a mitigator that can reduce the charge or lead to lesser sentencing. For example, it could be the distinction between a Class 2 felony conviction for sexual assault and a reduced charge of Class 4 felony attempted offense if there is intent involved. Now, let's explore how mental health defenses apply to sex crime cases in Arizona. Sex offense allegations in Arizona are some of the most serious, with tough penalties and long-term implications such as prison time and sex offender registration. In instances where there exist questions of mental illness, these can impact the prosecution and defense of such cases, but only in very specific legal situations. Insanity defense in sex crime cases. In Arizona, the defense of insanity, also known as guilty except insane, GEI, is provided in sex offense cases if the defendant can prove that at the time of the offense they had a severe mental illness that could not have made them aware that what they were doing was wrong. Some example applications include a person who is delusional or has psychosis and commits a sexual offense, believing their actions are in some way justified or that they will not impact the real world. Or a defendant who has schizophrenia or a similar qualifying mental disorder and actually lacked the ability to distinguish right from wrong when he committed the act. However, it is rare to win on a GEI defense in a sex crime case. The defense is heavily burdened, and not all mental states are eligible. Furthermore, if the defendant is found to be GEI, he or she is typically committed to a secure mental health facility, perhaps for as long or longer as would have been a prison sentence. Diminished capacity in sex crime cases. Whereas, in some other states, reduced capacity is used as a contention that an illness of the mind reduces one's capacity to form the criminal intent required, the Arizona statute does not make it available as a defense. This ruling was reaffirmed in the U.S. Supreme Court decision Clark v. Arizona of 2006, when the court affirmed the state's power to exclude evidence of mental illness for the express purpose of excluding criminal intent. Under Arizona law, ARS Section 13502, mental health evidence is permitted only in support of a guilty except insane plea, not to contend that the defendant did not have intent because of mental impairment. That means in Arizona, a mentally ill individual diagnosed cannot use diminished capacity to reduce or eliminate culpability. Only if mental illness meets the tight criteria for the insanity defense can it be offered, and mental illness considerations may be raised at sentencing in hopes of seeking leniency, but not as an independent defense. Next, let's take a deep look at the effectiveness of insanity and diminished capacity defenses. Not every defense strategy applies in Arizona sex assault cases. The insanity defense, when the defendant needs to prove they knew they could not understand the nature and the consequences of their actions when they carried out the act, is especially challenging, and usually due to the rigorous requirement of proof. Few defendants' mental incapacities will be good enough to persuade the court. Similarly troublesome for the diminished capacity defense, arguing the defendant's mental state undermined their intent, is the Arizona legal system. Few defense strategies end up winning. Arizona sex crime cases present severe challenges for those defendants who try to utilize insanity or diminished capacity defenses. The heavy burden of proof makes it hard to adequately establish the state of mind at the time of the offense. Moreover, juries are generally reluctant to believe these defenses because of the severity of sexual assault and the strong need to protect victims. Let's not forget the legal and public challenges of using insanity. The use of insanity or mental health defenses in sex crime cases is both legally and ethically questionable. Such defenses are riddled with great challenges and are generally controversial, both in court and in the minds of the general public. Public perception. The majority of the cases of sexual assault in which defenses of insanity or diminished capacity are claimed arouse concern in the public domain as to the genuineness of such claims. Any suggestion that the defendant is not fully in charge of his actions has the potential to create controversy and suspicion among the public, and hence skepticism about the utility of such defenses in doing justice to victims. Lastly, we need to go over the risk of misuse or misunderstanding. The term insanity is often misunderstood by juries and the general public. It is sometimes seen as an attorney's technical trick or a means of evading responsibility, especially in hot-button, high-damage sexual assault cases. This can raise doubt, undermine psychiatric evidence, or stigmatize mental illness. In effect, while mental health defenses are well within the law and sometimes necessary, they are difficult to prove, strictly regulated, and typically subject to doubt. In Arizona sex crime cases, these hurdles are increased by strict legal standards and the intense emotional and ethical stakes in the charges. If you or a loved one is facing a sex crime charge and mental health is a concern, you need an experienced Mesa sex crime lawyer who understands mental health defenses. The mental condition of a person can lead to criminal activity, but in Arizona's sex crime cases, the judicial system has strict criteria. As we have already explained, the nature of such cases warrants a proper understanding of Arizona's criminal code, court practice, and the interaction of law and mental health. If you or a loved one has been arrested and charged with a sex crime, and mental health is an issue, don't risk your future. Contact us at VS Criminal Defense for a confidential consultation. With experience defending clients in serious cases and in-depth understanding of Arizona law, our experienced team of Mesa sex crime attorneys can review your case and create the optimal defense. Call us at 480-923-9001 or visit us online at vsattorney.com.
Thank you for listening to the VS Criminal Defense Attorneys podcast. VS Criminal Defense Attorneys are focused on offering clients personalized service and aggressive representation. Our attorneys are passionate about individual rights, government accountability, and personal freedom. No matter what you are charged with, our criminal defense attorneys will be there to guide you. Call today to schedule your strategy session. It is time to fight back.